Hey guys, what's going on? Aaron Bennett here. In this video, I am going to talk about filing a claim. So right now, if your crypto is not accurate to what Celsius says they owe you, you have to file a claim by, I believe, January 3rd. Definitely just get it done this month. I'm going to play a clip from David Adler, what he thinks about everybody potentially filing a claim. Now, this is ongoing. They may actually introduce a new claim form, so we don't have to do exactly what he's saying, but I just want to let you know what a lawyer representing the ad hoc group for loans is saying about filing a claim, even if your crypto is accurate.
Generally, your proof of claim has to state your evidence for the basis of your claim. So, with respect to the claims that are claims other than for crypto, let's say violation of consumer laws, breach of fiduciary duty, misrepresentation, fraud, RICO, whatever you want to throw out there, especially the fraud claims. Think of your proof of claim as being like a complaint, where you just have to lay out a short and simple, plain statement of the facts that give rise to your claim. That would normally be all that is required. You don't want to, you have to say something more than just breach of fiduciary duty. You have to say something more than just, violation of consumer lending statutes. You have to lay out the facts, and it gets a little bit more complicated because when you allege fraud, you have to allege it with particularity. So I guess what I'm saying here is that everyone has a different situation. Try and put the facts out related to the misconduct that you relied on as a separate addendum. Okay. You can always amend it, up until the point that it's objected to. And as the examiner's report comes out, which will be coming out after the proof of claim deadline, you may want to use some of the facts, assuming there are facts in there that support what you're alleging, to file an amended proof of claim. But, the point that I want to make is don't forget about claims other than crypto. And that's what I've been saying for the last week, 2 weeks. Two, you can put on an attachment where you list the facts. And three, you don't label it. Just list the conduct that was wrongful. All right. And list, for example, all the representations made by Mashinsky about how everything was safe, right? That it was your coin, whatever you want. That is a breach of fiduciary duty misrepresentation claim. But I'm saying that, because of the nature of these claims, you have to sort of say it with particularity. So you may be required at some point in the future, to sort of amend that claim to really state it. And the whole point of this exercise is, at least the way that I look at it, it's really twofold. One, somewhere around there's a director and officer liability policy that ensures Celsius and the officers and directors of the company. And I've heard, nobody can tell me, but I've heard that policy is in the high eight figures, like somewhere in the $50 to $100 million range. I don't know if that's true or not. That's what somebody told me. But you want to be able to assert that claim because presumably the claims are going to be asserted against Mashinsky and others for breach of fiduciary duty, misrepresentation, fraud. And if the D&O policy pays out, based on his conduct, you want to make sure that you have your claim in there so that you participate, in those recoveries. If you just list your claim as a claim for crypto and that's it, I'm not sure you get any recovery. If those claims are ultimately resolved and settled. That's point one. And point two, which is it's a very technical legal point, but technically all the claims against Mashinsky that hurt the general creditor body reside in the estate right now. It's part of the debtor's estate. And there's this doctrine under New York law that basically prevents one wrongdoer from suing another wrongdoer. It's been the subject of Second Circuit law. The way I've gotten around that issue in the past is when there's a plan, I ask for individual creditors to assign their causes of action to the estate for prosecution. So in other words, you get around that legal doctrine of one wrongdoer can't sue another wrongdoer. And this is really in the bankruptcy weeds, but it's a reason why everyone should file a claim so that the estate or the post liquidation trustee will be able to pursue these, hopefully free of that doctrine, which is called in pari delicto.
All right, guys. So that is David Adler saying what he thinks and why he believes most people should file a claim. So I understand that this is confusing, and what we all want is just for this to be over and for you to know exactly what to submit as a document. So this is where at the end of your claim, you can submit some documents. I believe you can upload an actual document. So right now, the claim form does not allow you to claim against breach of fiduciary duty, misrepresentation, fraud, things like that. I will be obviously letting you know if a new claim form comes about. I know that there are a few people who are asking Kirkland and Ellis, Celsius's lawyers, to create a new claim form where these things are very easy to check, like a check mark, right? You want to have a claim against all of these things. And it's not like, hey, go ahead and create your own PDF and go upload it. So if I find a PDF or a document that is circulating that has like a general claim, I will let you know. Make sure to subscribe if you don't want to miss that. I can't promise that. I will just let you know what I'm hearing. But in this audio, I would suggest re-listening to it again, taking some notes. He does mention some things that you could include in a document. But again, if one comes about, I will let you know. And if a new claim form comes about, I will obviously let you know as well. All right, guys, so that's it. I just wanted to update you with this, and I will keep you posted because that's what I'm doing here on this YouTube station. So till next time, guys, talk with you soon, and bye for now.